Hello everyone, my name is Brandi Parigian. I'm a Public Relations Master's student at Full Sail University, and this is my research case study assignment for my Legal Aspects of Media class. I will be discussing two very important cases, the New York Times versus Sullivan case and the Gertz versus Welch case. Our first case that I'll be discussing is the New York Times versus Sullivan case. What led to the dispute was Sullivan's name was mentioned in the newspaper. Included in the text were the names of 4 individual petitioners and more. The advertisement included statements where some were false about police action allegedly directed against students who participated in a civil rights demonstration. The police commissioner, L.B. Sullivan, sued the New York Times after he took offense to the ad. Sullivan felt his reputation was damaged by the New York Times because of an advertisement that was placed in their paper that included statements that were false about police action allegedly directing students who participated in a civil rights demonstration. He had been libeled. The elements of defamation in the First Amendment requires the plaintiff to show the defendant the statement was false or was reckless in deciding to publish the information without investigating whether it was accurate or not. Also included in the 14th Amendment, it states that damages to a public official for defamatory falsehood relating to official conduct. The plaintiff had to prove by convincing evidence that the defendant published a defamatory statement with actual malice. The Alabama court ruled in favor of Sullivan, finding the newspaper ad falsely represented Sullivan in the New York Times. After losing an appeal in the Supreme Court of Alabama, the New York Times took its case to the United States Supreme Court, arguing that the ad was not meant to hurt Sullivan's reputation and was protected under the First Amendment. In a unanimous decision, the United States Supreme Court ruled in favor of the New York Times. In order to prove libel, a public official must show the newspaper acted with actual malice. The next case that I'll be discussing consists of 2 parties, Elmer Gertz, the petitioner and lawyer hired by a family who are suing a police officer who killed a family's son. Elmer Gertz is also a private person and needs to prove only negligence by the publisher of the American Opinion to collect compensatory damages. Then we have Robert Welch, who is the respondent in this case. The American Opinion reacted by publishing an article declaring that Elmer Gertz led a frame-up of news show and was part of a communist plot to discredit local police. Gertz was said to be a Leninist and a communist fronter with lengthy criminal record. None of those statements were true. Elmer Gertz ended up representing himself, suing for libel. The accuracy of these allegations against Gertz happened when the managing editor denied any knowledge of the falsity of the statements concerning petitioner and stated that he had relied on the author's reputation and his prior experience with the accuracy and authenticity of the author's contributions to the American Opinion. The end result of this case ends by Gertz winning over a jury verdict and an award of $50,000, but lost his libel suit because the trial judge found that the magazine had not violated the actual malice test for libel, which the Supreme Court had established in the New York Times versus Sullivan case. The Court of Appeals for the 7th Circuit affirmed in the trial judge's ruling. What I would have done differently than Robert Welch is I would have made sure I got the correct facts about the situation before the article ever published. It's very important as a journalist, blogger, or publicist, etc., to do the research to back up your story or claim. It's always important to remember that you make sure that any claim you make is in your content. Whether it's about your own products or services, that any general research you find is backed up. There are 2 parts of fact-checking that accompany backing up your claims. knowing your sources, and being sure that your references are correct. These allegations have affected Gertz's reputation as a lawyer and a citizen. When the respondent, Robert Welch, published false statements, in the end, though, he won $100,000 in actual damages. The Chicago lawyer, who was called a communist by the John Birch publication, demonstrated actual injury in part of testifying to his own mental distress, anxiety, and embarrassment. The defamation law in the state of Florida. Defamation is a false statement of fact communicated to a third party which is meant to hurt the plaintiff's reputation or economic well-being. Allowable Florida defamation damages consist of actual damages, compensatory damages, and punitive damages. Florida is one of the few jurisdictions where criminal defamation statutes are still in the books. While Florida doesn't specifically define criminal libel or slander, the state's law protects the financial services industry by making it a misdemeanor to define companies in that industry. If there's anything I learned from researching the Sullivan and Gertz cases, it would be to make sure that the work I publish has all the correct facts and information before it's out in the public. As a future potential publicist, it's important to execute the correct information to the public about my client or company that I work for. They will be constantly in the public eye, so their brand image must be managed properly through the creation of newsworthy happenings. Here are my references used in my case study assignment, along with my photo references for Sullivan versus the New York Times and Gertz versus Welch. And this concludes my presentation of my research case study assignment. Thank you for watching.